How have recent legal changes affected high-value estate and trust litigation? Estate and trust litigation usually involves issues such as disputes around trust distributions, contests concerning the validity of a trust or an amendment, or concerns regarding fiduciary breaches. Although these issues can arise in any case, the way these issues are handled in high-value trust litigation in particular is subject to change based on new laws being passed and new court rulings setting precedents regarding how a trust is supposed to be handled. As trust structures change to become more complex and involve new, diverse assets, the legal landscape around trusts and disputes will have to adapt as well. As a result, it's essential to stay on top of these legal changes and ensure that trust drafting and administration are centered around, focused on, and comply with these laws. Understanding the common changes to trust litigation will empower the trustor to take steps to prevent litigation after their death, as well as allow interested parties to preserve the best interests of the trust after the creator has passed. Adapting to change involves having skilled legal representation who's well-versed in the evolving landscape of trust litigation and understands how to navigate it with the best interests of the trust beneficiaries in mind. New legislation and new legal precedents may impact trust litigation. Here are some of the recent legal changes that have the potential to impact trust litigation. Complexity of trust structures. A common emerging trend is that trusts are becoming more complex and intricate, which leads to trust litigation. This is especially true for high-value estates with complex, high-value assets. With more advanced structures, there's increased responsibility placed on trustees, who have a fiduciary duty to act in the best interests of the trust beneficiaries and responsibly manage all the trust assets according to the trust document, which, as I said, is getting more complex. Complex trust structures may include assets in different international jurisdictions, differing distribution terms, or unique assets. There are also a variety of trust types that each have their own benefits, such as life insurance trust, dynasty trust, charitable lead trust, qualified personal residence trusts, slats, slants, grats, idiots, and more. And it's the trustee's responsibility to administer these trusts as dictated by the terms of those trusts. These complex trust structures and more demanding fiduciary roles are more likely to lead to conflict around how an estate is managed. Disputes in litigation can arise over that management, and those claims can be raised against the trustee if beneficiaries feel that the trustee is not acting prudently enough, or quickly enough, or in the way that they think they should in managing the trust and distributing its assets. It's important to have experienced legal advice around these structures in order to ensure that trusts are not only established in compliance with state and local laws, but that they're being administered according to those laws to ensure that the trustor's wishes are being followed. Estate tax exemptions. The federal estate tax exemption and gift tax exclusions change yearly, as set by the IRS. So this should be a constant consideration for proactive estate planning and trust management. The gift tax exclusion in 2025 increased to $19,000, an increase of $1,000 from last year. In 2025, the lifetime federal estate tax exemption also increased, rising from $13,610,000 in 2024 to $13,990,000. For 2026, the lifetime exemption is currently set to revert back to $5 million, indexed for inflation around $7 million, pending further congressional intervention. However, there is speculation that this may change, so it'll be important for clients, financial advisors, fiduciaries, and other interested parties, including estate planners, to remain informed and determine what adjustments might need to be made to be responsive to these things. The Corporate Transparency Act. The Corporate Transparency Act became effective on January 1st, 2024, and requires certain entities to disclose the beneficial owners of that entity to the Financial Crimes Enforcement Network, or FinCEN. This act applies to limited liability companies, corporations, and limited partnerships, all of whom must report. A beneficial owner is any individual that owns or controls at least 25% of the company or partnership, has notable substantial control over the entity and decision-making, Is a trustee or beneficiary of a trust holding at least a 25% ownership interest in the entity at issue? Is a trustor with the ability to revoke or withdraw assets from a trust holding at least a 25% ownership interest? For entities created before the CTA went into effect, the initial deadline to file was January 1st of this year. However, Texas District Court struck down the legality of the Act in two separate cases, leading to a nationwide injunction of the Act, suspending its requirements. While the Supreme Court stayed the injunction in one case, it did not address the other. Therefore, FinCEN announced that reporting was not required. That said, the future requirements are uncertain, and it's important that corporate entities with beneficial owners are prepared to meet any newly created deadlines in the event that those requirements are subsequently reinstated. What are key implications for trustees and beneficiaries? With changes to trust litigation and administration and the laws that affect those things, it's vital that interested parties, such as trustees and beneficiaries, are prepared to adapt. Some key implications of some of these changes include increased scrutiny of trustees. Potential changes to laws affecting trustees mean that trustees must be as informed as possible regarding their role so that they're well equipped to act within the best interest of the beneficiaries and minimize the chances that their actions are questioned. Essentially, they need to make sure they're discharging their fiduciary duty. Tensions among beneficiaries. Changing tax exemptions or trust terms can affect a beneficiary's portion of what they're going to receive from a trust, which may lead to confusion or even frustration among the beneficiaries if they're not receiving what they thought they were supposed to receive, which happens often. Challenges to establishing or changing trusts. Changes to laws and legal precedent may make it more difficult or perhaps even easier for a trustor or a trustee to either create or modify a trust, including irrevocable trusts. The importance of communication. Personal representatives, trustees, any fiduciary should keep beneficiaries well informed about what's going on with the estate and why they're making decisions regarding those estate assets. It just helps eliminate misunderstanding and helps avoid disputes. Beneficiaries, trustees, and other interested parties in an estate should not hesitate to seek legal support when necessary. The support and guidance of an experienced estate and trust administration attorney will help not only simplify the process, but increase the understanding and ensure that the administration is successful, efficient, and productive. Here's a lesson from the Murdoch family trust case. In December 2024, Murdoch was attempting to amend his irrevocable trust in order to ensure that his son, one of his sons, Lachlan, would assume full control of his media empire when he passed. A Nevada probate commissioner denied that effort, emphasizing that the two parties, Rupert and Lachlan, were acting in bad faith by attempting to alter control and making changes that violated the fundamental principles of the underlying trust. In particular, the modifications did not protect the equitable treatment of all of the trust beneficiaries. The probate court also found that the trust was set up as an irrevocable trust, which means that the arrangement features limited ability to change and can only be altered with the approval of all of the beneficiaries, or unless the standard for modification has been met, which was not met here. This case highlights the importance of structuring a trust in a way that makes sense for your estate and your possible goals. As one of my old mentors used to always say, it's important to plan for maximum flexibility. So in case you find yourself looking to alter the trust in the future, you can do so. It also highlights that no matter how high value the estate is, there may be no circumventing trust or estate administration laws based on your wealth or status. A probate court is always going to try to act objectively, regardless of the status of the estate at issue or its value. If you're concerned about your case and how it might be affected by recent trust or estate law changes, you should meet with a qualified probate litigation attorney who can walk you through those laws and what their potential impact might be. At RMO, we protect people like you every day. Contact us today to see how we might be able to help.